client's perception of winning a good result in a design and construction dispute is often different from the perception of their lawyers as to what constitutes a win. I think that when a settlement is in a client's best interest often depends on many business and psychological factors besides the strength of the case. Who's getting the blame? Who's getting a bonus? And increasingly and importantly, can we just get this behind us and focus on what we do best? I mean, there is an architect in the world that went to study architecture because they want to talk to me for 100 hours in a year and sit for a deposition and answer my questions and help me handle litigation. And I think that this is one of the reasons why our clients' perception of what is a win can vary wildly from the perception of their attorneys. And yet, most of our clients in design and construction do not have enough experience to necessarily challenge their lawyers on the advice that they're giving. A lawyer might say, we've got to do X, Y, and Z. We have to plunge forward in litigation. And, we can't talk about settlement until we've got all their documents or taken all the depositions. And, I think our poor clients just have no, means of saying, well, that doesn't really seem to be, in our best interests. We view winning a different way. What do you say we try something else? It just is, it's a conversation that doesn't happen enough, in my view, with enough force from people who run design and construction companies. And, it kind of shocks me that often these factors are overlooked or even unknown by counsel who focus primarily on litigation-based risk analysis, which isn't necessarily what's necessary to meet our design and construction clients where they are. And I think that might be one of the reasons why lawyers are reluctant to recommend mediation. As I've discussed in the past, mediation is no panacea. I've had so many bad mediations, but I don't think it's because mediation was inherently a bad option. I think it's because if the table isn't set right with the right processes and procedures and mediators and mindsets, you're almost guaranteed to have a mediation that doesn't result in a settlement. And these lawyers who are reluctant to recommend mediation or really any real settlement process until we're well into discovery, I don't think that they're serving the interests of their clients. And part of it may be a failure on the part of these attorneys to perceive what does it mean for our clients to win. And almost always it's the case, not always, but almost always it's the case that their interests lie in achieving early cost-efficient dispute resolution. And, one of the most important points that my former law partner and current mentor, Paul Lurie, who really developed guided choice mediation, or at least kind of branded it and collected these best practices of, a wide variety of excellent mediators, sort of in one place and one framework. One of the things he helped me understand is that the key to there being good and earlier settlements for all the parties is to understand what the disputing parties consider their best interest based outcomes. And I think the most important word that I just said was the word understanding. So I will repeat that it's critically important to understand what the disputing parties, meaning our clients, the people who we serve as design and construction attorneys, what do they consider to be their best interest based outcomes? And when we understand what those interests are, and we understand, what is in the disputing party's mind, then, we have the ability to achieve early cost-efficient dispute resolution. And it sort of begs the question, what is causing, the impasse to those understandings? What is it that is preventing so many attorneys from understanding, what their clients perceive as a win? And I think that that's one of the things that guided choice dispute resolution really gets at. It creates processes and procedures that helped to push aside some of these misunderstandings that lead attorneys to focus on litigation-based risk analysis and things that are not interesting to their clients. And then once we understand what's preventing these lawyers from understanding what their clients really want, um, you know, how do we, overcome those misperceptions? And I think that one of the things that really is important about guided choice dispute resolution is the focus on the process for trying to figure out what's really in everybody's best interest. Why is it that we're having a hard time all agreeing, on what it is? Why do we not understand what it is? What is causing us from not understanding? And then, what is it that can be done to help overcome those perceptions, or really, I'd say misperceptions? What is the dollar and business expense? What's the risk and reward of getting to a final resolution? On the one hand, by expensive adjudication, or on the other hand, early cost efficient dispute resolution. And a lack of understanding, I believe, by many attorneys about what makes their clients tick is one of the things that is an impediment, but also a key to getting cases settled, early and on good terms. And certainly, I would never suggest that we do any baby splitting, or that we surrender our client's position or best interests in order to achieve an early settlement. I don't do that. I don't think that good construction lawyers do that. But this lack of understanding about what our clients care about, is something that, merits some discussion, because, these cases tend, unfortunately, to not settle early and on good terms. Usually they settle late. As the case approaches trial, the parties' views about risk and loss and outcome and expense tend to shift. And at the beginning, when we all wanted to, have this selective attention to facts, well, I'm only going to look at these facts because they help me, and the other side's only looking at these facts. That tends to fall away when you get to the end, of the dispute. And then this optimistic overconfidence in our own position tends to fizzle out, and people wind up in that proverbial courthouse steps settlement that is, in my personal view, and I certainly don't have all the answers, but my strong view is a huge waste of our clients' time and resources. And, we can debate why, this is a phenomenon, not just in design and construction litigation, but in a lot of high stakes civil commercial disputes that are resolved through litigation. But I think that we can agree that it tends to happen on most design and construction lawsuits. And I believe that it starts with many clients perceiving differently what a win means than their lawyers. And if the lawyers can figure out what's a win to their clients a little bit earlier, and can focus on the processes necessary to explore whether they can achieve early cost efficient dispute resolution, or whether this is the very rare case where it can only be resolved by taking a case all the way to trial, I think that we design and construction attorneys can do our clients a great service.